Federal High Court sitting in Abuja has ordered the Department of State Services (DSS) to allow freed but still detained leader of the indigenous people of Biafra (IPOB), Nnamdi Kanu access to medical doctors of his choice. The Federal High Court in its ruling on Thursday held that Nnamdi Kanu should be given access to all his previous medical records in possession of the DSS. Nnamdi Kanu has remained in DSS detention after Court of Appeal set him free of all terrorism charges leveled against him by the federal government. Nnamdi Kanu's lead counsel, Michael Zekome, had filed an application requesting Justice Binta Nyako of Federal High Court sitting in Abuja to issue an order to allow the detained Biafra leader to have access to medical doctors of his choice and previous medical records, citing the deterioration of the IPOB leader's health at the DSS detention facility. DSS in reaction filed a preliminary objection asking the court to decline jurisdiction in the matter, arguing that the request had been settled by another court in Abia State previously. The judge, Justice Binta Nyako, dismissed the objection of the DSS, saying the Secret Services failed to respond to issues raised by the applicant regarding his health.
Rendition from Kenya back to Nigeria on the 27th of June 2021. Today, the court agreed with us that the reliefs we ask for must be granted, and the judge granted. What were these reliefs? That Nnamdi Kanu be allowed access to medical doctors of his own choice, as earlier also ruled by this honorable court since October 2021, but which ruling was continuously, serially, and contumaciously breached by the SSS. Today the court ruled that he was entitled to have access to his medical practitioners of his own choice, and that these medical practitioners should be present whenever any examination or procedure is to be done on Mazi Nnamdi Kanu outside the facilities of the SSS, and that such examination or procedure should be recorded. Should be recorded. She made that order. She also made the order that all his medical records should be made available to him. Because in any event, it is the right of a patient to have access to and see his medical records so that he can always have a review and update on these medical records. She couldn't see why such a simple demand should be denied him. The SSS had filed a preliminary objection that this action was similar to the one earlier filed before this court and also before the court in Umuahia Federal High Court. The court held that that was not true, that the parties may be similar, but that the course of action was certainly different. Because in that action, Mazi Nnamdi Kanu had sought for the enforcement of his fundamental human rights, which were granted by the Federal High Court in Umuahia, sitting in Umuahia. And guess what? The court had imposed a fine, damages of 500 million naira against the federal government of Nigeria, which, as I speak to you, has never been paid, and we begin to take steps to enforce that judgment. since the olive branch we have held out in the last 2 years has not been responded to.
According to the ruling, a person arrested and detained shall have the right to demand medical attention by medical practitioners of his choice. Consequently, the applicant is entitled to medical attention of his choice but at his cost. This application succeeds and is hereby granted, the judge stated in court. Adding, Kanu's medical practitioners and the DSS should be present whenever examination is conducted on Kanu outside the DSS facility. The court ruled that the procedure should be recorded while the DSS should supervise for security purposes.